Going live tonight. It's time to rock and roll. Hey, everybody, welcome. We're live tonight, live on YouTube. Let me see. Okay, welcome, Advocates for Justice Paralegal School. We are different and we prove it. So, guys, tonight we're going to update you on the win and show you the ROA sheet, or I call it the docket sheet, so you can see the beatdown that the attorneys took. We're also going to talk about the number one goal in foreclosure defense, and it's not to block the sale of your house. We'll get to that, and we're going to update you on what we got going on new. Yeah, my wife is asking me if you're going to stream tonight. I was like, yeah, we're streaming tonight. She's like, wow, I don't know how you can come up with so much stuff to talk about. So I just let her know what we're talking about is stuff that attorneys are doing to people, the illegal stuff they're doing to people, and figuring out ways to stick it back up in their face. We just getting started. So, update on the wind. I think I showed you guys the last time we received the email confirmation of the fact the judge terminated the case the day after receiving our counterclaim with her name added to it. And I'm thinking the reason they didn't send us the regular paperwork, they're supposed to send you paperwork and stuff that's been added to the case, is because they probably don't have a form that they can fill out when they get their ass kicked. Yeah, they don't know what to send us, and they ain't trying to send us nothing with the judge's signature on it, because the judge is not trying to piss off the people at the bank or the attorneys, because I'm sure they all invested in the judge's campaign contribution thingy going on. So we didn't get the actual order, but what we got was good enough for us. And there ain't nobody in my family's face. There hasn't been anybody in their face since this started for them over a year and a half ago, and nobody's been taking pictures of their house or doing all those customary things that they do to try and steal your hope. So I'm going to show you guys the docket sheet. And we're going to do that right now. As soon as I figure out how to do screen share. Then I got to remember to turn the screen share off, because I forgot to turn it off yesterday in the last half of my video with the screen share on. Okay, so this is the docket sheet. They call it the ROA report. I call it the docket sheet. And you guys can just follow along. It's about 5 pages long. We're not going to spend a lot of time on it, but I want you guys just to kind of give you a blueprint of what we went through. Now, keep in mind, our goal is to stay in the house. Okay, our goal is to stay in the house. Our goal is not to get before the judge or to end this or none of that stuff. Our goal is to stay in the house. So they want to drag it on. We're going to block them from doing what they're trying to do, and we're going to make them try to block us from doing what we're trying to do until they want to bring the judge out. So you'll see how this rolls. But looking at this, the first thing that you're going to notice is this is all of their stuff that they served us, but they have affidavit of military service of the defendant, but they don't have an affidavit. They usually have their customary affidavit of the facts, that the attorney looked at the facts, which ain't shit, but it's something. They don't have nothing here. So without an affidavit to start the case, to have a witness to testify, because attorneys can't testify. They got shit for the program. And that's pretty much what their program turned in. Yeah. So there should be an affidavit here that the attorney filed, and that affidavit should be the affidavit from an injured party. Okay. But there never is an injured party because of the fraudulent way they do this shit. So, but there still should have been their customary affidavit that they attest to the records. So you're being sued by the records. So you get to cross-examine the records, I guess. And I don't know. They've got this program all twisted up. And if you go in their program following their twist, well, you already know what happens. So let's just scroll down here. And you'll see we never answer to them. We responded, and we responded with our counterclaim. And you guys can do that. You can respond with your counterclaim. If you have defenses, especially jurisdictional defenses, you can respond with those defenses before you have to answer to them. And only if they beat you down, your responses, you have to reply. Only if they win, you have to answer to them. So from where I'm sitting, like you said, seeing what we did right here, we did this for a whole year, year and a half, and we could have kept on going because their stuff is so naughty. They've been so naughty. So you can see return of service, and we'll scroll down. And then they got the IRS involved. And right here is where we came in with our response. Not an answer, it's our response. We filed a $5.5 million counterclaim for wrongful foreclosure, and the attorneys kind of blew it off. Now, state court don't have jurisdiction here, $5.5 million claim. So what they should have done was they should have dismissed the case and forced them to refile it, or I don't know. All I know is they don't have jurisdiction here, $5.5 million claim. And if we file this as a claim in their case, it caused a problem for them. And the new package that we're setting up, we're going to have it set up where you can do either or. You can file it as a counterclaim, or you can file it as your own lawsuit against them. There's advantages for both. I don't really see much disadvantages, but there's an advantage for doing both. If you file it as a counterclaim and you add the judge to it, then that jams up the decision maker, that jams up the judge, and puts a little stop to their little program. So that's something that you can consider, and that's something that you guys are going to have to figure out on your own. So right here, Exhibit A and B, when we filed this counterclaim, we attached a copy of the passport showing that my sister was a state citizen of the Republic state in which she was born in. And we also provided as Exhibit B was the affidavit of state citizenship that I put together. And they sealed both of those documents, which is interesting. And I don't understand why they sealed them, and they wouldn't explain it to us. So I have to go and make my own assumptions here. I think they sealed them so they would not have to respect the fact that she is a state citizen and she is not subject to the court's statutory jurisdiction without injured party. When you can verify you're a state citizen, you're not subject to the court's statutory jurisdiction without an injured party. And that's where we hinged our first challenge of jurisdiction on. There's no witness, there's no injured party. As a state citizen, the court does not have jurisdiction over a state citizen when there's no injured party, because it's common law. So that was a problem for him, but we didn't really notice that until further down the road. And this attorney here, I don't remember even seeing her name on the paperwork. So And you know, when you guys when we go over this, you're going to see a pattern. I want to see who notices the pattern. If you notice the pattern, then just type in the chat window that you noticed the pattern. I noticed the pattern, so I can see, and then we'll talk about the pattern at the end. So right here, right here, we filed a motion for sanctions under Rule 11, and this jams up the attorney. So once we filed the motion for sanctions under Rule 11, this attorney came on and filed an entry of appearance. Now, these attorneys file the entry of appearance because they are a foreign agent. And as a foreign agent, you have to file an entry of appearance in a court case because you're from another country. Okay. Now, this is the biggest tip, one of the biggest tips I'm going to give you guys. Okay. And it's free. A foreign agent cannot file a claim in state court. They have to file their shit in federal court. Think about it. You can't sue someone from another state in state court. You have to use federal court, let alone another country. A foreign agent is from another country and they file their shit in the wrong court. So court don't have jurisdiction because this foreign agent filed this stuff in state court and should have filed it in federal court. Foreign agent, what are you talking about? Dude, the fact that they filed the entry of appearance verifies fact they're a foreign agent. Bam. Open and shut. That's how we roll around here. Open and shut. So we just slap that in their face. And then we file the demand to strike the plaintiff's notice of appearance from the record because the foreign agent, okay, we already went over all that, right? So we want to strike the notice. And when you do that, you pretty much wipe out everything they filed. Well, if the judge granted it, but we already know the judge ain't trying to grant nothing, okay? You are not going into court hoping the court's going to give you something the judge is going to rule on. No, that's not what we're doing here, okay? What we're doing here is we're building a record and forcing the judge's hand to do shit without jurisdiction so you can sue the judge in the end, because in the end, the judge is going to help them. And you need to have the record built that you need to hold the judge accountable for what went down. Okay, that's what we're doing. I had a lady telling me yesterday she didn't think she wanted to get in the program because she was having trouble when I told her she was going to have to go after the judge. And so my comment was, well, I'll see you later. Good luck. I told her I didn't want to take her money, okay, because I already know how that's going to go. I'm going to spend a whole lot of time arguing with somebody and then we're going to have drama. No. We already know from the 598 Facebook members in the group, we already know how this is going to go down. We already know how it's going to go down. So we filed that motion for sanctions, and then they filed a motion to dismiss the counterclaim. And then they had somebody answer on behalf of the USA, which is ridiculous because the IRS is not, the IRS is a corporation like Walmart. They don't have shit to do with the government. You got to be kidding me. So then we filed a motion for a summary judgment. And the plaintiffs responded to the summary judgment. And then they got a new attorney. And then the entry of appearance of the new attorney. And we did some research on her. Her name wasn't on their website. We did some research on her, and she just got added to. We found on the internet where they were welcoming her to the firm. She just got added to the firm a couple of months earlier. And that's the other thing. These attorneys are not supposed to. They had their court rules will not allow them to represent pro se. Okay, and you want to make them have to do that so you can sue them for that too. So that's what we're doing. We'll get to that later. So here's another entry of appearance, and I was going to color code these so you can see all the different entries of appearances, but I ran out of time. And then we filed a motion to dismiss for with prejudice for lack of subject matter jurisdiction. So there are several types of jurisdiction. The two main types of jurisdiction that we talk about in this situation is subject matter jurisdiction and personal jurisdiction. Now, the attorneys will argue, and you'll see, and if you look at some of the stuff that the attorneys will argue, oh, you know, the property was here, so the court has personal jurisdiction, blah, blah, blah. Yeah, but they don't have subject matter, and they have to have both. Okay, they can't have one and not the other. That's not the way it rolls. So we filed a motion to dismiss for lack of subject matter jurisdiction, and then they filed a motion for extension of time. Oh, wait, they already filed their lawsuit, so they shouldn't need any more time. But remember, our goal is to stay in the house, so they can take as much time as they want to. We're going to keep filing stuff. Okay, we're not going to sit back and wait for them to answer that, and as you'll see. So there was an order for an extension of time. Then the plaintiff responds to the motion to dismiss with prejudice. And then the defendant's reply to the plaintiff's response to her motion to dismiss foreclosure with prejudice for lack of subject matter jurisdiction. Then the plaintiff's motion for a summary judgment. The plaintiff filed a memo on the motion for a summary judgment. And then we filed a motion to, we filed a demand to strike the plaintiff's notice of appearance on the record. A corporation cannot represent itself in court. Yeah. And then we filed another motion for $150,000 in sanctions pursuant to Rule 11 for that attorney. And we challenged the court's jurisdiction in the demand to strike the attorney's pleadings in violation of, because they're a violation of Kansas Rule 65. The court lacked jurisdiction as the plaintiff failed to prove jurisdiction on the record. And then they filed for an extension of time to respond to the motion for $150,000 in sanctions. And then a motion here for an extension of time to respond to the challenge to the court's jurisdiction. Boy, they need a lot of extra time. Yeah, but I've got some ways we're going to cut this time thing down because I don't like that was a lot of work. I ain't having to have everybody have to do all that work. But keep in mind, that the one goal is stay in the house and make them give up. So there was an order, respond to a motion, respond to the challenge, court's jurisdiction, or generic. Oh, now we have another attorney that came on, the new entry of appearance. Oh, okay. Let's see what this guy's bringing to the table. So they respond to the motion for sanctions, a motion to dismiss or summary judgment from the defendant. And then, so we filed a demand to strike William Myers' notice of appearance as the lender is not a party to the action. The attorney cannot verify agency and is acting as a debt collector, collecting on their own behalf. Bam. Yeah, that jammed him up. And then the plaintiff filed a motion to strike the defendant's motion to dismiss the summary judgment. And then what? Plaintiff's filing for an extension of time again. You guys need so much time. So while they're filing for extension of time, we were figuring out how to use that time in our favor. So what we did was we motioned to moot all of the pleadings filed by the four attorneys until the attorneys prove subject matter jurisdiction on the record. Subject matter jurisdiction on the record. There. We became a little more specific since they beat around the bush and think that we're only talking about personal jurisdiction. Okay. So that's what we did. And then we came up with the jurisdictional challenge with an affidavit. That document was structured, was created. That document, along with the document with the motion to moot, when we filed those two, and I'm just going to tell you right now that the attorneys can't respond to that because they can't respond by counter affidavit because everything they're doing is a lie. Now, Michelle Alexandra Jacobs, I don't remember her even being in the middle of this either or seeing her name on. So that was weird when I saw her name on there. So she withdrew of counsel in 3 of her appearance. I guess she came in to help Mr. Myers again, and it was a little too hot in the kitchen. So she had to get out. So then the attorneys filed a little weak ass response to our jurisdictional challenge with an affidavit, and they did not file by counter affidavit. So, bam, they're done. So we replied to the attorney's response to the jurisdictional challenge with an affidavit, motion to dismiss for lack of subject matter jurisdiction. And then we motioned for a hearing on the jurisdictional challenge with an affidavit because we're getting kind of tired of all this stupid shit that they're pulling. So we're just going to go ahead and move forward and ask for a hearing. And we never did get the hearing. I don't think they heard us asking for a hearing. They have trouble with their hearing and can't hear us. Okay, sorry. I got carried away. So then after we asked for the hearing, they ignored us for a little while. And then they scheduled a hearing on various pending motions. And actually, there was no pending motions because they were totally in default. And we defaulted them like, I think twice, maybe 3 times, but I think we defaulted them at least twice. So they wanted to have a hearing. So they had the little Zoom hearing, and we're not even sure if it was the judge because they didn't tell us about the hearing. They just called her at the last minute. My sister at work and had the hearing there. So they had the hearing, and after the hearing, the judge said that the defendant that my sister had 30 days to prove full payment. Remember, this is the judicial foreclosure. So, and the judge told the attorneys to go and enter a journal entry. And we looked up what a journal entry is. And a journal entry is where the attorneys agree on how to dispose of the case so the judge don't have to rule on it. And we didn't agree. So we objected to the journal entry. And then they offered her. So then the judge dismissed pretty much all of our stuff. And they offered my sister opportunity to come down and inspect the promissory note at the attorney's office. Now, that's ridiculous because the note should have been filed in court. A certified copy of the note should have been filed in court to provide the court with jurisdiction. So, and why we have to go down there and look? Yeah, we already know how that goes. So when they did that, we were just waiting. Okay, we were waiting for the judge to get involved and help them because we've learned through our Facebook page and all of the people that are fighting that the judge helps them all the time, unless you go sit down and give up. And even then, the judge still got to help them because they got to grant them some shit. So once the judge came out and helped them, this is what we sent over. We filed another notice of claim against the judge for violating the Administrative Procedures Act of 1946, obstruction of the administration of justice, violation of constitutional rights under the color of the law by making a determination without jurisdiction. Then we filed the notice of recusal, and the next day, well, no, and then we filed for entry for judgment. I think the attorneys must have filed that one. Motion for entry of judgment. Maybe the judge gave up sooner than I thought he did. So we filed a notice of recusal to recuse the magistrate judge under section 455, and it didn't require service, demand to strike the attorney's motions to enter journal entries. And they came out with a new attorney. I think this was the 9th attorney, the 8th or 9th attorney. And my sister served this attorney at his house, and the attorney that was defaulted 2 or 3 times got really pissed. And you see here, he entered his entry of appearance, and then served a couple of motions, and then we just stopped playing. We found that we filed a $20.5 million counterclaim for a violation of the Foreign Agent Registration Act of 1938, the Fair Debt Collection Act practice, wire fraud. Well, I added the wire fraud and mail fraud and RICO on there because you can't sue them for that, but that's illegal stuff that they're doing. And I just added it on there because I can. So, yeah. And it kind of reminds them of what they're facing if, this is going to go all the way. And then, as you can see here, the next day the case was terminated. But we didn't know because they didn't send us anything or tell us that the judge terminated the case. And I'm going to tell you right now, the difference here, I think one of the biggest differences here is the Foreign Agent Registration Act. Okay, that's the first time I ever used it actually in the lawsuit. And I think that between that and the Fair Debt Collection Act practice, because they're violating the Fair Debt Collection Act practice because they're misrepresenting themselves. They're misrepresenting themselves as the corporation that has consideration in this alleged debt, and they don't have no consideration in shit, and it's not a debt. But I think the biggest factor here that caused the judge to go sit the hell down was the Foreign Agent Registration Act. And that's a federal law as well as the Administrative Procedures Act. So I think one of the things that we're considering doing now, I'm putting together the state package based off of this report and what we filed. And obviously we're not going to have to file everything that we filed here because the book that I use for this is pretty fat. So we don't want to have to be going through all of this much stuff. Okay. So we're going to do what we can do to cut to the chase. That's what I always say. We're going to cut to the chase. So I'm thinking this new package that I'm putting together for state court, so we won't have to be driving miles and miles to federal court and going through all of that hassle. This new package we're going to have this lawsuit here in a notice of claim letter, so that when you respond to their challenge to their foreclosure against your property with your jurisdictional challenge with an affidavit, you can add this letter addressed to the judge. It's a notice of claim. You can make it a notice of claim letter to the judge that you're notifying them that you're putting the judge on notice right now that you're going to file a claim against the judge. Now, judge ain't done nothing yet, but what the hell? We already know. We need to have that 30 days counting already, counting down, okay? And we need to let them see what you're going to be doing in the end if they don't get their shit right. So that's kind of, I haven't made the final decision on that yet. I'm still in the process of going through this and marking the documents that we have, that we filed, and figuring out what it is we can take out that we don't need to file, because I was just messing with these people. Okay. So now, as you can see, after we filed that, the attorney kept objecting to our stuff. And he was really, really pissed. And he said that our documents were scandalous, impertinent, and yeah, a bunch of other words I had to look up. He was really freaking mad. And that's the way to get when you slap him in the face. So then we kept filing a couple of more things. He filed some other stuff. So we just kept responding to him. And then I decided that I was done doing this, and I was going to just move the case over to federal court, move his foreclosure, the state foreclosure that the attorneys filed, over to federal court. I think I can do it. So I started researching what I need to know to be able to do that. Oh my God. Yeah. So you can move, any party can move for a change of venue in the interest of justice. Oh, how sweet is that? So I put together the change of venue package, and I think I have it like $50. And yeah, I think Shamel used it. She was the first one to use it. I was getting ready to use it, and I went through this docket sheet, the new docket sheet, and then I found that the judge had already gave up and went and sat the hell down. So the attorneys are lucky, because they would have been pissed. Yep, you can move their stuff over to state court, move their state court lawsuit over to federal court in the interest of justice, because the attorneys are a foreign agent, and they should have filed it in federal court in the first place. And they do not have a stinking affidavit they do not have an injured party. They do not have a witness. That's what we did. So the number one goal, well, let's check and see how many people we got here tonight. We got a couple of people here. Howdy, guys. We're doing what we do because we don't play. Well, thank you, BT Trust. And you guys will enjoy my online course teaching you how to defend your properties. And I think it's something that all churches should invest in, because you invest in that, people can come to the church and sit down and watch the videos and look at them, take their notes and print off what they need. That package is the bomb. So Mike Williams, how to retrieve old docket sheets from old courthouse cases, and who do you get it from? I don't know that, Mike. I'm not an attorney, so you would have to call the courthouse. You should be able to look up. I don't know if you're talking federal or state, but Most state courts, you can go to the courthouse, or some places you can do it from your home and access their docket sheet and pull up your case and have them print off, you know, whatever it is I would have them print off the docket sheet, the whole thing, so you can look at everything and see what's filed and figure out if there's any specific things on there that you need to look at. Okay, we're going to move forward. And the number one goal is to stay in your house. The number one goal is to do whatever it takes to stay in your house, not to block the sale. People call me all the time and they're fixated on blocking the sale, and we need to block the sale. And no, the number one goal is not to block the sale. The number one goal is to have a strategy in your program that's going to block the eviction process. Now, with that being said, if you block the eviction process, you're going to block the sale. Okay. But the reason I'm saying it this way is because you can get yourself caught in a trick bag if you make blocking the sale the most important thing. You can block the sale, you can tie that shit up, and they can still evict your family into the street if you don't have a plan to block the eviction process. Now, the eviction process is usually done in a lower court, particularly in a non-judicial. In a non-judicial, they send the eviction process to a lower court. That court only has the authority to make a determination on immediate possession issue. Okay, and this is why people get smashed in eviction court. You go into eviction court, you're arguing the same shit you was arguing in the other court about how you own the property and what the servicer did and the lender and all this stuff. That's a title dispute. Okay, eviction court ain't trying to hear that. All the eviction court wants to hear is the immediate possession issue. Now, this is jacked up, okay? Because if you go into court and you start arguing immediate possession, no, I get immediate possession because I have the property, the paperwork, and I have now you're back over to a title dispute. We can't hear you, bam, and now they just judge for the other side. Yeah, it ain't fair. It is not fair. So the way you get around that is you make sure that you have your title dispute filed on the record in federal court. This is how we put the program together before we started to learn how to kick their ass in state court. You challenge the eviction court's process, and then you can remove that whole process from eviction court over to be connected to your federal lawsuit. Because at the end of the day, the immediate possession cannot be determined until the title dispute's been settled. And the title dispute's in federal court. And once the title dispute's settled, then the judge can make the determination on immediate possession if it's not done in a settlement offer. Yeah, there's that, the settlement offer. So the key to this is when you start filing your stuff, to not sit back and wait for the state court judge to rule on your stuff. Get your shit filed and then get it moved over to, and then file your lawsuit in federal court and get it moved. Now, I say all of this, okay, because it works great when you have the time to do it. But if you don't have the time to do it, you got to do what you got to do, okay? You need to have that lawsuit filed in federal court as your title dispute. And in the package, you have the removal document to remove you have a regular jurisdiction, a challenge of jurisdiction, and you also have the jurisdictional challenge with an affidavit that they can't respond to. I would file the jurisdictional challenge with an affidavit, stick it right up in their face, and then take a file stamp copy of that the next day and attach the removal document, attach that file stamp document from state court to your federal court removal document and as an exhibit, and file it in federal court and ask federal court to add this to your case because this is an immediate possession issue, and immediate possession cannot be determined until a title dispute's done. Bam. And they think they so smart. And once you do that, you can file a restraining order in federal court to restrain state court's ass, because they have a hard time sitting the hell down and following the law and the rules like they're supposed to. So that's how you do that. But if you leave it all sit over there and you wait for the judge to rule and you wait and all that, then of course they're going to throw your stuff out and they're going to force you to sue the judge, which is where you're going to end up at anyway if you're following our program. Okay, because you're going to follow whoever helps them steal your house is whose ass you're going to sue. I play football in college and I box, so I like to keep it simple. So that's how we're going to roll on that. Whoever signs to help them, you're going to add to your lawsuit. Keep it simple. Turn the heat up. Now, what's new? We're working on a new, well, actually, I have it structured already. I'm getting ready to put it together. I was hoping to have it done tonight, but I didn't. The phone rang, and I have other stuff. Yeah, but I'm still working on it. So what we got going on new is I've got a couple of people that got bills from the city for sidewalk repairs. And the city started a new sidewalk improvement program where they send you a bill. They come out and look at the damage in the sidewalk out in front of your house. Yeah, the same sidewalk that they built when they structured the street. That's the sidewalk. They want to make homeowners pay for the repairs. And if you can't afford the repairs, then they're going to take that money that they're charging you for the repairs and come and attach it as a lien against your property, just like they do the illegal property tax, and then take your property later on because you couldn't pay to fix the street. Oh, excuse me, the sidewalk connected to the street. So that whole thing is a scam. So we're put together a package that people can use for that. And this package that I'm working on, people can use it for other things that the city is trying to charge you for. And I'm going to put a link to that video here so you guys can see it. I'm still working on the package. When I get the package done tomorrow, I will post it. Now, you guys need to remember on my videos, I post a link to whatever I'm talking about or whatever's important inside the description area and also in the comment area. Now, maybe not in all of the videos, but the newest ones, that's what we're doing. I'm kind of learning how to do this as we go along. So here is the link to the new video that I posted yesterday about this sidewalk thing. Yeah, BX Stress. Yeah, we bring in the heat. And now in this document addressing this sidewalk issue, we're also kind of touching on the fact that they have your deed illegally in their office, and having that deed in their office is what gives them their misguided authority and control over your property. If they didn't have that deed in their office, they wouldn't be able to be charging you, coming after you, sending you bills for stuff because they wouldn't have your property information in their office. So we're addressing that in this simple document, that letter, that notice of claim letter that I put together in the end. Because if they did not have your deed in their property, they would not be able to harass you and keep doing all the stuff that they're doing to you. As a matter of fact, the whole illegal foreclosure is basically real estate deed fraud. And I'm going to tell you why, and keep it simple. It's real estate deed fraud because each state mandates that each state deed transfer laws, statutes mandate that the deed be delivered to you after the sale. Did you get your deed delivered to you? Hell no. No. What they did was what the attorneys call their constructive delivery, and they registered your deed in their office. And once that deed is registered in their office, now they're able to charge you, their corporations are able to charge you, put a lien against your property for stuff that they say you owe them and jam you up. And then if you can't pay, then they have these fools their buddy attorneys that come in and buy these liens and then try to take off. Yep. All because they have your deed in their office, registered in their office. And you know what? There is no law or statute that mandates that you have to put your deed in their freaking office. So the property tax, the code and zone harassment, all of that shit, you're consenting to by not telling them you want your shit back. 3 months. And my eliminate property tax lawsuit package is the best thing that you can use for that. So we're going to get this sidewalk improvement program notice of claim letter done and sent and posted. So because I have about 6 or 8 people that are already ready to go. That they watched the video that I posted last night, and they're pretty excited to have a chance. And you know, it's really sad because when you watch the video, you'll see what they do in the video is they tell you that, you know, all the statutes. So you go to the statute, and the statute says, oh yeah, a bunch of double talk, and then the statute refers to the ordinance and the code. So you go to the code, the ordinance, and the ordinance is a regulation. So what the hell's a regulation? Okay, so now we got to figure out what a regulation. Oh, regulation is a rule, a municipal rule. Are you kidding me? A municipal court don't have jurisdiction to do shit, and it gets its judicial authority from the city ordinance. Now, what corporation can provide itself judicial authority and be doing all the stuff that they're doing to people? Well, they do because people don't know. But people are starting to find out now. So now I want to share with you guys a couple of my offers. And we got today is super deal day. Tonight is super deal night. Super deal night. Now, the eliminated property tax package is one of my most popular things that people look at, invest in, and go to my YouTube channel. So tonight, we're going to throw down. We're throwing down because we can. And the eliminated property lawsuit package has been marked down below half price. It's low. I got it marked down to $250. I'll tell you what I'm going to do. I'm going to mark it down. The attorneys hate this. I marked it down again. Now, there. Stop giving me pressure. Yeah, now it's marked down. It's marked really down. It's marked down to $200. The $500 eliminated property lawsuit is marked down to $200. Now, you can use this to control the foreclosure also. Yep. Hell, you sure the hell can. But you probably would be better off if you're about to get pushed off the edge of the cliff and facing eviction. I probably wouldn't go this route. It's a longer route. But if you're not about to get pushed off the cliff, then hell yeah, you can use this to jam up their foreclosure and demand them return your freaking property deed to you. You want it all. And I also put together this offer because I know a lot of folks relied on their credit card during the pandemic to take care of their families, and now they're struggling, wondering how the hell they're going to keep these attorneys out of your bank account and from garnishing your wages and shit. And this is how you're going to do it. This is my lawsuit package against attorneys for credit card debt, credit card fraud. Oh, one other thing too. This is super deal weekend. Actually, super deal month. So I marked down the prices on both my judicial and non-judicial lawsuit packages for the rest of this month. They're marked down to $300. What a deal. Are you saving 200 bucks? Now, what you guys need to be doing is going in on this shit with a neighbor or a friend or somebody, so you don't have to pay the whole amount. And then you get the files when they get emailed over to you. Then you can email the files over to whoever it is that went in with you guys, so you guys can both do this without anybody having to be broke. You're welcome, Mike Williams. This is what I do. They pissed off the wrong person. That pissed me off, and now my lifelong journey is to help people learn how to kick them in the face. And I don't know if you can tell or not, but I love what I do. And I got some free steaks in the mail the other day, so that was pretty cool. My sister's pretty happy. So it's interesting. My wife told me, my wife always has some really smart things to say. My wife told me one day, she said, "Yeah, well, now that you got a win, you can stop telling people it ain't about getting the wins, because people always want to know how many wins you got and all that. It's more about making attorneys go sit the hell down and get out of your face." But now that we actually got a win where the judge actually went and sat the hell down and got out of our face, I guess I can talk about the win a little bit. Yeah. Good evening, Ralph. James Galley. Welcome to the group, guys. We covered a few things today, and we got something new that we're sticking out there that we hope to have done here early next week. Hopefully, I'll get it done tonight. Well, no, the night's almost gone. We'll get it done. We'll get it done tomorrow. There's always tomorrow. There's always tomorrow. I'd really like to have some of you guys that invested in the lawsuit package and the eliminated property tax lawsuit package come on and let us know how things are going with that. And I also have the new motion for a change of venue. It's like $50. That's one badass motion. You should be able to use that to move their case over to federal court and screw up their whole program, because the attorneys, the state court case law cannot be in federal court, but federal court case law can be in state court. And that's pretty much what I use all the time anyway. So I don't have to worry about that. So you can move their stuff over to federal court and just mess up their whole program. I can't wait to see how they handle that. So you guys should check that out. That offer's on my website too. So I think that is about all I have for you guys tonight. When I get the new package put together, I'll have a stream next week about it. And I'm also going to post it here on the comment section down below. And when I get done with the sidewalk improvement program known as a claim letter, I'm also going to post it on this video in the comment section. So I will see you guys in the next video, and have a great weekend.